Could you please turn off the audio if you're live streaming it? The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. Welcome to the Massachusetts Appeals Court. Today is Tuesday, June 8th, 2021, the last day of oral arguments for the 2020-2021 court term. Before we begin, I think we should take a moment to remember Justice Rudolph Cass, who passed away on Friday. He fled from Germany when he was 3 years old, right after the Nazis took over. Certainly not the first time and definitely not the last time this country has benefited from taking in a refugee, as he served on this court for 24 years from 1979 to 2003. I only had one case before him, though he ruled against me. I sought further appellate review and I lost that too. But it was a good, wise opinion, and I came to agree with him. He was I didn't serve with him, of course, none of us did, but he was a frequent visitor to the court. He kept in touch with us. We did see him several times, and I had the pleasure of serving with him on the Massachusetts Law Review for many years. So I would ask that we have a brief moment of silence in memory of Judge Cass. Thank you. May his memory be for a blessing. All right, that having been done, this is video conference A3. If you're looking for Judges Mead, Kinder, and Han, you are on the wrong channel. Please go back to YouTube and type in Massachusetts Appeals Court and you'll be able to find them. But if you're looking for us, I'm Justice Joseph Ditkoff, and with me is Justice Sabita Singh and Justice John Englander. And we're the panel for the one case we're hearing today. Once we start, the seal will be replaced by a clock, which will count down for the time. We have had some trouble with the clock, but I will be paying attention if there is a problem, and I'll make sure everyone keeps their time. You are both no strangers to the Massachusetts Appeals Court, so you know we have no rebuttal, and that we have read the briefs and we have gotten into the appendices, and you'll be best served in getting right to your argument. With all that said, I will call the first and only case that we're hearing, Yazzie versus Town of Millbury, number 2020 P30. We will first hear from the town. Attorney Notice, you have the floor.
Thank you. May it please the court, Gareth Notice for the Town of Millbury. I'll cut right to the chase on the argument and skip over the facts and the key dates, which I'm sure the court is well aware of. I think there's one thing that the trial court, the appellee, and the town, the appellant, are in agreement about, and that's that 85H1/2 should not be applied retroactively. If that statute was the only statute in play and it held its place alone, the case should have been dismissed. There quite frankly is no language, plain and simple, in the statute that allows it to be applied retroactively. And there is no case law interpreting the statute that says that it should be applied retroactively.
So counsel, I don't know what you mean by retroactively. I mean, the statute was in effect at the time that, at every relevant time that anything occurred in this case, right?
Well, what I mean by retroactively, Your Honor, is that it was not adopted until 2011. And I think the legislative—
By this particular town. That's not a
correct.
Retroactivity analysis. That's an analysis of whether the adoption by the town under the statute would apply to someone in the plaintiff's circumstances, right?
And we could call it retroactivity, or we could call it something else, Your Honor. But
you make much in your briefs about calling it retroactivity and addressing case law that talks about retroactive applications of a statute. And to me, that's not what this is about. This is about construing the language in the statute that says in any city, town, or fire district which accepts the provisions of this section.
Right, Your Honor. And it also has the language notwithstanding. And that language was put in the statute with specific legislative intent. And that specific legislative intent was to circumvent any pre-existing statutes that existed, such as 85H. I think there's clear case law to suggest that the court should, and this court has,
To
given that word.
circumvent, I didn't see any case or any legislative history that you had cited to us, counsel, about circumventing Section 85H or supplanting Section 85H or anything to that effect. What are you citing us to?
My reply brief, Your Honor, where we talked about the meaning of the word notwithstanding. And it's been defined in several places. The court said in DeGulia versus Director of Department of Unemployment Assistance that the plain language of the word notwithstanding clearly signals the drafter's intention that the provisions of the notwithstanding section override conflicting provisions of any other section. That's what I'm referring to, Your Honor. I'm also referring to the—
Okay, all right, but let me just stop you there. Let's assume that's right. The word notwithstanding means that it would override any conflicting provisions of any other statute.
Correct.
Where does that get you? I don't understand where that gets you with respect to the analytics that we have to do here.
Well, it gets us to several places because it applies to both the statute of limitations argument, because in 85H, we have the requirement that existing insurance policies must be exhausted, and versus 85H and a half, where we do not have that. It also applies to the fact that that statute should not be utilized to use the date of 2009 as the date on which the court should apply the benefits of 85H and a half. And so I think it applies in several places.
I'm sure that my colleagues will have some questions, but I found this difficult to follow. So let's start with this. 85H, maybe we can clear out a little underbrush. 85H is part of this case. It was in their complaint. Are you at that point yet, or are you still gonna?
I don't agree with that, Your Honor. It was not in the complaint.
It is. It's right in the complaint. It's in the first paragraph of the first complaint.
It's not a pled count.
It's not a separate count. I agree. But okay, so you want to, okay. Let's move past that then.
Sure.
To me, that's a sideshow. 85H and a half can only apply here after it's adopted in 2011, right?
I can agree with that.
Okay. So the question for us has to be, does the adoption in 2011 apply to the plaintiff who was injured in 2009?
And I don't think it should apply, Your Honor.
Okay.
I think that would lead to an absurd result that is contrary to statutory interpretation and the legislative intent here.
And the reason for that, just spin out the reason for that is?
Well, the reason is that the legislator included the acceptance language. The legislature gave towns such as Millbury the option to accept this or not accept it. And if they do accept it, then that has severe financial consequences to the town going forward. If the legislator wanted it to apply to injuries that occurred well in the past and would provide perpetual liability to the town, the legislator would have specifically said that. It did not.
All it said was in any city, town, or fire district which accepts the provisions of this section. So one way to read that would be, once they've accepted the provisions of the section, it can apply to someone who was injured before. From that point forward, that's one way you could read it. There's nothing. Is there anything that precludes that?
Well, I think just logic precludes it, Your Honor. If it applied completely into the past perpetually, we'd have a situation where towns were faced with challenging the causal relationship of an injury or whether or not the employee was injured in the line of duty for injuries that happened, in the 1970s and the 1980s.
Isn't it the case that anyone who would be eligible for benefits under 85H and a half would have already been eligible for benefits under 85H? It's the same standard, right?
It is the same standard, Your Honor.
So wouldn't a town know that you have the people you're paying $3,000 a year to under 85H, and those are the people that would be bumped up to $50,000 or whatever it is when you get 85H and a half? Wouldn't that be a determinable number, what the liability was?
Yes, it would be. But the difference is if you look at 85H, there's also that same remedy in there. So if the town had a permanent firefighter, which MILLBURY did not, then they would be on the hook for the same remedy that 85H and a half provided. And so what the legislator, I think, was doing with this was giving towns the option to say, look, we recognize that some towns are providing private insurance, like MILLBURY was to its firefighters. Along the same lines of 2/3 of what their pay would be, we're going to give you the option to accept this statute. And if you accept it, then you're taking a significant financial investment in your firefighters, and there's no need to go get private insurance. And so I think that's what the legislature was intending to do, giving the towns the option to do that. If the legislature didn't want to give that option to the towns, it wouldn't have included that acceptance language in 85H and a half. And so I think that's why it's so critical.
It clearly wanted to give the towns an option. I mean, I read it differently. I read it to be along the lines of Judge Ditkoff's question. 85H applies to those towns like MILLBURY that have no permanent firefighters. That person gets $3,000 a year. That's all they're going to get because there's no comparator to get more. There's no permanent firefighter. So 85H and a half comes along and says, well, if you want to give people in a town where you have no permanent firefighters more, you have the option to do it. Isn't that another way to read these two?
And that's kind of, I think you can't have both. I don't think they should be read in harmony. If the legislator wanted them to be read in harmony, it would not have included, as the trial court wrote, it would not have included that notwithstanding language.
Now, let me ask you this.
In 85H and a half.
Now, for the next firefighter in MILLBURY who gets injured and is incapacitated from his regular service, does he get the $50,000 and the $3,000?
No, I don't think so. I don't think you can double dip like that, Your Honor.
Why can't you if we can't read the two in harmony?
I don't think the court should read them in harmony. I think they should read them.
If I don't read them in harmony, then each statute applies, and 85H says he gets $3,000 a year, and 85H and a half says he gets the $50,000 whatever year, and so he gets.
And right? that's the alternative remedy that I argued to the court, Your Honor, was that if the court's going to allow 85H in the case and say that it applied here, then the remedy should have been the $3,000. That's what it should have been. It should not have been because the injury occurred in 2009. And so it should not have been, that doesn't, merely because the town accepts it, doesn't mean that the town then at that point had an obligation to go forward and correct every firefighter who was accepting under 85H and suddenly bump them up.
Which is the way that the courts below read it, counsel. And that is that it's not everybody from 1960 forward. It's someone who they may have been injured before the acceptance, but their ability to get paid had not yet accrued because they were getting insurance from the town. And
Yes.
Your response to that is, well, now you're adding something into 85H and a half that isn't there. You're adding that disability to, not disability is the wrong word, but you're adding in the paragraph that says you can't get paid until your insurance has been exhausted.
Right, and I think
but if you read it that way, then it's limited, right? If
It
you
is.
read it that way, then it's limited.
It is limited. And I think the reason it was left out was because of what I was talking about before, that There's no need for firefighters to go out and get private insurance and have an exhaustion of some private disability policy because they're getting a substantial windfall under 85H and a half. The legislator left that out, and its omission is glaring when you compare 85H to 85H and a half. The
Is
reason
there
they
any
left it out is
legislative
just
history
about
on
the-
85H? Any legislative history of any value?
I searched long and hard, Your Honor. I didn't find any. It was drafted in 1943. It's been around for quite some time. And the same thing for 85H and a half. I scoured looking for legislative history and was unable to find anything that, addressed why certain language was omitted that was included in 85H, and certain language was included, like the notwithstanding language, and why that was in there. But I think that's why we can look to those cases that I cited in the reply brief about, the intent of notwithstanding. And the notwithstanding language was a clear signal from the legislature that 85H should have been trumped. And this court has used that specific word, trumped.
Well, I mean, the most obvious explanation for that is it's saying even though under 85H you would get 3,000, under 85H and a half you're going to get more than 3,000. Notwithstanding what we said back here in 85H, you get more. Can I ask you why hasn't the town offered the $3,000 a year that he's clearly entitled to?
Well, because the town felt that there was a viable statute of limitations argument in the case, Your Honor, and procedurally, the 85H was not.
What was the viable statute of limitations argument with respect to 85H?
The injury occurred in 2009, Your Honor. That was the
85H says you don't have a claim until your insurance is exhausted.
I'll also say this, Your Honor, that 85H was never presented to the town. It was 85H and a half was presented to the town, and the town manager rejected it because it had not been adopted. 85H was added to the case after the summary judgment motion had been served by the plaintiff on a motion to amend the complaint. And so that's why it was never considered in this case. We were well down the road procedurally through discovery, through depositions. I was faced with a motion for summary judgment and had to prepare a summary judgment motion before 85H was even included in the case. And so when we went to argue before the judge, he said, fine, I understand you're prejudiced a little bit. I'll give you that opportunity to file a supplemental brief. And if you want to reject 85H, I suggest you file a motion to strike it from the complaint. That's exactly what I did, and it was denied. So that's the reason why it's never been paid in this case, Your Honor. Now we're on an appeal, and we're trying to work this out. So I hope that answers the question as to why, it was never considered. It was never presented to the town until we're into the summary judgment phase of this case.
Does the town still purchase disability insurance for its call firefighters?
No, it does not, because it's adopted 85H and a half.
And your position is once a town adopts 85H and a half, 85H has no application.
That's correct, Your Honor, because it provides such a higher windfall to firefighters, and it's automatic. It doesn't distinguish like 85H between whether a town has permanent or non-permanent firefighters. And I think that's also a signal from the legislature. It didn't give that distinction between the two classes of towns, a permanent town versus a non-permanent town. It provides such a great windfall to firefighters.
I don't understand the word windfall, and I don't understand the last argument you just made. What do you mean it doesn't distinguish between?
Because 85H said that if a town has a permanent firefighter, it must provide the 2/3 remedy. If it doesn't have if it's a non-permanent firefighting town, it provides the $3,000, i.e. MILLBURY. When the legislature enacted 85H and a half, it didn't make that distinction. It didn't provide two separate remedies based upon whether a town had permanent or non-permanent firefighters. It just said, look, here's a substantial benefit. We're not going to impose it on you necessarily, because we understand a lot of these towns are smaller. They have volunteer firefighting forces. They don't have permanent police and fire. But if you choose to accept it, then you're on the hook for this, and I call it a windfall. It's not a windfall, but you're
Doesn't
on
seem
the
like a
hook for this.
windfall to me. It seems like something that was voluntarily undertaken by the town in order to compensate people who are injured in the line of duty.
Well, it's Mr. Shasha has filed a lawsuit arising out of this case. He's recovered in that lawsuit. He's also working full-time as a bus driver, earning close to the same amount of money that he applied. So in a sense, it is a windfall, Your Honor. It's double dipping, frankly. And I don't think that was the legislature's intent when it enacted that statute.
All right, I think we get your argument. Thank you very much.
Thank you.
We'll now hear for counsel for the employee. Attorney Jacobs, you have the floor.
Thank you, Your Honor. May it please the court. Mr. Shasha meets all the requirements to collect benefits under Section 85H1/2. The stipulation of facts indicates that there are no disqualifying circumstances. The stipulation of facts also indicates that. When he became injured in 2009, he was eligible for and collected under the National Union insurance policy that MILLBURY had provided for its firefighters. He was not eligible at that point in time until exhaustion of that policy pursuant to 85H to get any other benefits. He could not get the benefits of 85H. So that policy continued for 5 years through 2013. In 2014, several years now after.
When did his rights accrue under 85H1/2?
His rights under 85, I believe the legislature intended, although I have not found specific documentary proof of the legislative intent, I think you need to read 85H and 85H1/2 together, and that he cannot get benefits because he was collecting on the insurance policy. On January of 14 is when he would have had.
So another way, the Muse might say, Mr. Jacobs, that what you're really asking us to do is insert language into 85H1/2 that exists in 85H, but not in 85H1/2.
It is correct. 85H1/2 does not have that.
And the usual construction rules, usual rules of statutory construction would say what with respect to that argument? They would say the legislature knows what it's doing. The legislature knew how to write those words in 85H. It left those words out of 85H1/2. We should consider that to be a deliberate act of the legislature. What do you say to that?
I appreciate that argument, Your Honor. In that case, then, Mr. Shasha theoretically would have accrued benefits starting when MILLBURY adopted 85H1/2. It is an annual benefit by the statutory term. It is a separate benefit that accrues each and every year. He would then have lost the benefits going back from when he filed the lawsuit in 15, because he took 14 trying to work with the town and submit requests for the town for coverage under 85H1/2. He would perhaps have lost some of those benefits if the court determined that this statute has a 3-year statute of limitations. If the court thought it had a 6-year statute of limitations, and the statutes 85H and 85H1/2 are silent on the statutory limitations issue. So because it's an annual benefit and it's a minimum allowance, I believe Mr. Notice's argument that whatever other work Mr. Shasha may or may not.
You're putting a lot of, I understand your argument, counsel, and it's well made, but you're putting a lot of emphasis on the word annual. I mean, the way I would have read the word annual was not to give you sort of a repeating right each and every year, sort of an accruing right. You're reading it as if that means your right accrues each year. Another way to read that is simply it's defining the allowance as being an allowance equal to the annual salary.
I appreciate that, and that's a decision that the court will have to address if it chooses to address the word annual. I have not found any case law that addresses that phrase to determine whether my argument that it's an accruing on an annual basis, or your comment that it just means it's paid annually, meaning
So
one
how long
payment.
could you wait? Could you wait 10 years before you made demand and said, hey, I'd like my annual allowance now?
That would depend on two issues. One, what does this court determine is the statute of limitations for this statute, for
But see, that
85H and 85H.
concedes that there is a statute of limitations. I thought you were saying there's not really a statute of limitations because the word annual means my rights accrue each year separately.
But you're saying if I wait 10 years,
Right.
then if I would argue that, yes, I can apply, but the question still remains unanswered. What about 10 years ago? Has the statute run or the limitations period run on the first of those 10 years
I see what you're
claims?
saying. I see.
I
Thank you.
can still claim, but I may lose some of those earlier years if this court decides, and it's a discretion of the court. Do you want to address the statute of limitations issue with these two statutes and say whether it is a 3 or a 6-year statute? And then those earlier years would be barred if you do that. If that doesn't mean that your ability to collect going forward and back the amount of the limitations period is barred. There's no indication in the statute that that should be the case. MILLBURY adopted an enhanced provision that the legislature allowed the towns to adopt because $3,000 for a call firefighter, that call firefighter could have been a surgeon, an attorney, anyone in his community serving his neighbors. And the $3,000 amount the legislature felt is a small amount to recruit people to serve their community. So the legislature gave the communities the option to adopt an enhanced benefit. That still may not protect people of a higher earning capacity who serve their community.
So what do you, sorry, go ahead.
Just quickly, do you agree with Judge Tucker that laches is an available defense against a claim for 85H or H&a-half damages if there's an unreasonable delay?
I think laches is.
He wrote there was a
think,
fact on it. Do you agree with that?
Partially. I think it depends on whether the town would be prejudiced by the delay. If the town is not prejudiced, then I'm not sure laches should apply in that case. In this case, for example, the statute says Mr. SCIASCIA should get $3,000, period. It's a statutory mandate to MILLBURY. He hasn't collected one penny other than the Gladfelter National Union insurance policy. So whatever.
I don't think it applies to your client, but you agree that it applies in the abstract if the facts were supported it. Is that right?
I think laches is an applicable concept given the facts of an individual case. Okay. Yes.
I wasn't asking you to agree that it applied here.
For example, if a community had destroyed records going back many, many years and couldn't defend to decide whether that case were appropriate or not, then that community might have been prejudiced. I don't think that applies in this case at all, and I don't think it would apply in most cases, because if the town used 85H to retire a firefighter, which they had the statutory option to do, then presumptively all of those firefighters could have been retired who had been previously injured, and by 85H&a-half, they're not eligible for those enhanced benefits because they were retired. That was an exclusion that the legislature provided in 85H&a-half. It disqualifies you if you've either been pensioned or retired, or if you've been determined not disabled by a panel appointed by the community. MILLBURY
So
could have
your brother says, look, when your guy got injured, town hadn't yet accepted 85H&a-half. And it should not apply to your guy because otherwise there's no limit to this. The town has essentially taken on the responsibility for anyone who was injured in the line of duty who's still alive. And to read it that way is a disincentive to the towns to adopt because they could be taking on much more liability than they'd like to. What do you say to that?
He was not eligible to apply in 2011 when MILLBURY adopted the enhanced benefit. So in that context, MILLBURY knew of his existence. The fire chief knew of his existence and knew that he was on the insurance policy. So the town, when they voted, could have well been advised that this wouldn't possibly apply or should apply to SCIASCIA's case.
Well, they might have been advised of that, but only if somebody went through the mental gymnastics that you'd like us to go through of taking a clause that's an 85H and putting it in 85H&a-half in order to get to the predicate of your whole entire argument, right? Which is he wasn't eligible to apply when in 2011, the town accepted 85H and a half. You really have to go through that process, or the predicate for your argument disappears.
Then you would have to also find that after they adopted it, there's a specific limitations period, and that he is prevented from applying later on in time if he is still disabled according to the terms and the requirements of the statute. You'd have to find both things. And I don't think that's the case here.
That comes back to the word annual.
Correct. You would have to find against him on annual. You would have to find that he should have applied for 85H and a half, even though 85H made it clear he could not do that while he was taking benefits under an insurance policy. You would have to find against him on all those issues, and then basically put the fault on the firefighter who's been injured, who is trying not to double dip to the community. He is in good faith saying, look, I'm being covered by an insurance policy.
It's a little different than that. It's a little different than that. I mean, it really comes down to the question of whether, when MILLBURY made the decision to accept this, whether they should be taken to have intended to also benefit people who had previously been injured. It's not trying to put the fault on the firefighter. It's really asking the question of what is the impact of MILLBURY's decision in 2011 to accept.
But the statute makes no comment about when the injury occurs. The statute is totally silent on when the injury occurs. It talks about whether that firefighter.
I thought I didn't hear you fighting too hard against the notion that your brother advances that we shouldn't construe this so that it can go back 40 years.
I'm not saying that it can go back 40 years. I'm arguing that in SCIASCIA's case, I'm not arguing for all other.
Well, no, but that you understand my point, counsel, which is,
yes,
when you argue to us, the statute makes no, the statute says nothing about when the injury occurred. That opens the door to your brother's argument, which says, okay, so they could have been injured at any time, including 40 years earlier.
And if they were totally disabled and they were still within the community, and they were not able to return to the work, and they were not retired. I mean, if they were 40 years ago, they may very well have been retired by the community. Then you have the argument of latches. All those things you would have to find against SCIASCIA to rule against.
Latches is an equitable doctrine, and trying to import latches into what appears to be a common law analog claim, in which has been analyzed as if there's a statute of limitations. I'm not familiar with too many situations where we say there's a statute of limitations and there's latches. Now, I guess that's for us to figure out which should apply, but yeah, very interesting. Okay.
Well, I think it's also may be determined by how your honors rule on the issue of annual, whether that is a recurring annual benefit that accrues each and every year and then is calculated on an annual basis based on the average of the first year firefighter, then that would change annually based on the average of the first year firefighter salary for the 3 surrounding towns as determined by Peer Act. If you determine, and this is for the court to determine, if you determine that that's an annual process that Peer Act should undergo for the benefit of the town, because the decision has to come from Peer Act, then every year his annual benefit will be as determined by Peer Act. It may very well be changing over time. The question is, did the legislature intend, rather than having a cost of living increase, that the annual benefit would be adjusted based on the average first year firefighter salary? Or did the legislature intend it would be a one-time determination at the point in time that the award is made, and then it would never change? All those things have to come into play to determine whether SCIASCIA is or is not eligible for benefits.
What does the judgment say on that subject? What does the judgment say as to what MILLBURY owes SCIASCIA?
The court's judgment, as I recall, it says he's entitled to benefits under 85H and a half going back to January 1st of 2014 when his insurance benefits expired.
But it doesn't answer the question that, so it's a declaration, it's not an award. So the damages issue that you just raised has not been addressed?
We have not been given any financial determination by the trial court. There
How
was
did
no
this,
dollar
how did this
amount
get here
determined.
without a final judgment?
The judge, I can pull it up. It's Appendix 3, page 549, I believe, Your Honor. And I can pull it up and I can read that to you.
That is it.
My sense is you folks didn't brief that issue at all, right? That there was no argument about what you're just saying, which is how you calculate the benefit.
Um,
What was the page number?
Volume 3, page 549, Record Appendix 3, 549, Your Honor. What the judge did in his order, as I read it, is quoted the statute itself. He did not address the issue. He said such minimum annual allowance shall commence effective January 14.
I have it in front of me if you'd like me to read it.
I got it. No, I got it. So he did. I mean, he thinks he addressed it. Would be the way I read that, reading it very quickly. He thinks he addressed it. Okay, thank you. That's helpful.
All right. Any more questions from the panel? Seeing none, thank you both. This is a very interesting case, and the briefing and the argument's been very, very helpful to the court, and I thank you both. I'm especially happy to see, I think I speak for the whole panel, see Attorney Jacobs in good health.
Yes, Your Honor, thank you.
We're very pleased to see that. I'd like to thank our timekeeper. I'd also like to thank Joe Stanton, our clerk, and all his staff who's made it possible for us to keep going during the pandemic. And with that, court will be adjourned until Wednesday, July 7th at 9:30 a.m. We will be in person in the John Adams Courthouse in courtroom 4, which I think we're all very excited about. Thank you all.
Very well
Thank you, Your
argued, gentlemen. Thank you.
Thank you.
Thank you, Your Honor.